Good evening, friends. Welcome to the third edition of Conversation, initiative of the Gemba HR Forum. Today's topic is the new labor code and its impact on Indian industry. I have with me Deepanjan Dey, who is the Senior General Manager of Employee Relations in Imami Limited. Deepanjan comes with an illustrious career in HR, where he has worked in various manufacturing organizations. He's also an authority on labor laws and IR and has authored several articles. He also has a book on contract labor, which he has co-authored with others. Uh, I also have with me Vipin Arora, who's my alumni from XLRI. Vipin has an extensive career in HR in India as well as in the Asia Pacific, and currently he is the managing director of InvokHR Solution, which is his own HR consulting firm. Both of them have extensive experience in the area of labor legislation and its deployment in Indian industry. So, Dipanjan, I first would like to ask you that what do you think are the major benefits of the labor code, new labor codes which the government has introduced? How do you think the that has benefited and will benefit the industry in future? If you can share your thoughts on that. Over to you, Dipanjan.
Now, yes, so abrogation of useless and multiple register, there has been few improvement where by that is, but that was already in place. But because many state government has already started that consolidated kind of return that we do. Then amendment of Chapter 5B, the threshold limit has been increased from 100 to 300. But decriminalization offense, I tell you, in decriminalization of offense, the government has not fully decriminalized it. It has, of course, gone for some kind of compounding of offenses in all the courts, but decriminalization has not been removed. So overall, if you say it's a good start per se, but there are still lot to be done, lot to be desired as far as the industry is concerned. Yeah. Thank you. So this is my first perspective. Whatever you asked on, I think you can take it forward.
So, Vipin, I come to you now. So, this is the understanding that, most of the things which industry wanted to a large extent, this has been provided in the courts. What was industry's expectation out of the thing? The challenge which any practitioner of HR would know was that the acts also provided for a lot of things which is there. The biggest challenge was, of course, the implementation and how people would interpret laws and acts in their own way. And therefore, the compliance to, and of course, obviously, uh, it could not happen without the knowledge of the bureaucratic machinery. But this actually, diluted the importance of a labor legislative framework in the country. That actually the implementation of these acts were almost not there. What you read in the book and what you saw in industry was sometimes very different. So, in this context, what do you think are the mechanisms in which there has been improvement in the compliance part of labor legislation?
So, no, so again, thanks, Vinayak. First of all, I would also say congrats for starting this forum, and very happy to be here, and that too so early when you started these discussions. Let me just add a couple of things before I straightway come to your answering your question, and maybe I'm just adding a couple of things what Dipanjan had mentioned in terms of the industry expectations and all. I think to me also there are two specific things that come out is definitely intent wise. I think there has been a push towards ease of compliance, and some bit of maybe I would say too much of confusing things that we had in that. There has been an effort to really simplify some of that part. Now, uh, and I will take examples how in terms of implementation as well. The second part, I think the biggest challenge with the complicated stuff is it also leads to problem of transparency. It leads to the problem of enforcement as well. So because if there are different interpretations, there is always a insecurity. Have I interpreted it correctly? Am I doing it right? And becomes extremely difficult to justify or even say that whether it was intentionally wrong or there is a technical fault. Because there are times when, and again, linking it back to it, if it gets into the helm of maybe criminalization of that offense, it really complicates, because sometimes there may be intentionally, there may not be an intention to do something wrong, but maybe there is a technical understanding issue. And it's not only for the industry. And I would say it in so many words, even within the enforcement agencies, sometimes there is an interpretation issue. You talk to one part of ESI, and I will take you one example because this I have tried many times. There has been those issues of ESI on the driver salary. And I have talked to so many people from the ESI department. They themselves had an interpretation issue, whether how it should be taken. So I think the problem is when the acts are made so complicated, then there is an issue. Now, coming to the example of maybe specifically one example I will talk about is the code on wages, coming to the answer of how it can help in simplifying. See, there has been a huge uh, complication in terms of even the definition of wages. Now, when you look at Minimum Wages Act, it defined wages more like basic and special allowance and HRA. Payment of Wages Act again defines it basic, special allowance, HRA. When you go to Bonus Act, it says basic, DA, cash allowances. When you go to EPF Act, it says basic, then DA, then retaining allowance, then some other allowances. When you go to payment of gratuity, again, I'm just saying it's maybe last one basic and then DA, then maternity has some bonus element included in it. ESI Act has all allowances excluding bonus. So you understand the kind of maybe complication it has generated, that as a person who wants to even comply with the act, how does the person really figure it out that where what comes in? Now, unless you really become an expert, and then your expertise is getting wasted only for the compliance for that, and just trying to interpret the things. I think somewhere intention wise, now let's say code on wages, when they have combined one definition, yes, there will be complications out of it because there will be a transition issue, there will be lot many other challenges with that. But the point is, with one definition, perhaps we have 6 and 7 acts, there is ease as an industry, as a person who's complying it, and similarly as a person who is doing the enforcement, there will be an ease to understand and perhaps not multiple interpretations and challenges associated with it. And I think it will also remove some of the practices which even from may not be some of the best of the companies in industry, but there are some portions of the unorganized sector and maybe some of the companies which also try to use these sections in maybe some form to really not pass on the right benefits to the workmen also. So I think the enforcement becomes much easier. The second part that I think how the implementation can help is also the technology part. The more and more technology coming in with the and some of those things getting accepted now as a norm, things get better. And again, it may not be, let's say, code on wages or labor code, but for example, the simplification that came in the PF with the UAN, the technology facilitates. So I think even into the compliance method, the way the returns are filed, the way certain other things, I think that is how the enforcement and implementation will happen. On the industry side, I think many companies, even though it has not been notified yet for implementation, but many companies have already started moving in the direction of towards the compliance of what is suggested or what is proposed or what is approved in the wage code. So they have already started moving towards that direction. And I have seen multiple examples that companies have thought about it. They have started looking at some of the areas where they need to work on, and they have started improving their processes. So I'm sure that the implementation would be easy. I'm sure that it will be much faster. Yes, there will be some teething troubles initially, like any transition. And again, it will also depend on the preparedness of the companies, how prepared they are, because honestly, there has been sufficient time. We all knew from 2019, 2020, when these codes were passed, that in some or other form this is coming up. Maybe when the government notifies, the things will be applicable, but there has been sufficient time. It has not been an overnight change in the processes. I think there is sufficient time for the companies to get tuned to it and maybe start understanding and doing it. So I am very positive about it, about the implementation. I am very positive about it. My worry would be more now on the side of the enforcement agencies, how soon they will understand some of the things and be able to really make sure that when the industry is moving on their direction, whether they are also trained and everybody is trained down the line. It's not only about this uh, the maybe the ministries and the senior people, but down the level, the person who is talking and saying, I am coming for the inspection at your office, down the line, how people understand that and how they are also able to facilitate. Because one of the key thing is that the idea of the compliance officer as a facilitator for compliance versus maybe an inspector and auditor of non-compliance, I think there is a significant change in the mindset that would be helpful here. To what extent processes can help it? Perhaps we don't know. Processes can help to some extent, but there is a significant change in the mindset, which I think there has been some bit of effort towards that direction. And at least I am very hopeful that things will get better. Very long answer, but I'm just trying
Yeah,
to
no, understand.
share
In fact,
my
just
view
to
on
add on to this, I think some states, I think Uttarakhand, I remember, is that they have third-party agencies who actually
Uttarakhand, they have a third-party agency which has been now included
they do
in
the
the
audit for you.
Wastage Code.
So it is not that you have an inspector coming in; it's a professional agency which comes in and does your
I think
audit.
got struck or life got struck. Yeah. So yes, you are absolutely correct. Uttarakhand had a third-party agency now which has been incorporated in the Wastage Code. If you just permit me, Binayak, just
Yeah,
what
sure.
Vipin was telling, I would like to add one, two things. Vipin is absolutely correct. See, any law, forget for instance this labor codes, even that criminal code that came into uh, operations, new codes that have come into operation. I was listening to a lot of learned lawyers. One of the major advantages, the law evolves over the period, and the substantive law is actually evolves with the interpretation of the judiciary. So one thing that has happened with the old laws, Vipin was absolutely correct. If you remember, when we are at our younger age, we are at a junior level working with our companies, we had a lot of confusions about what is this, how it will be interpreted, as rightly it was being narrated by Vipin. But over the period, judiciary has dealt with every single issues that we used to handle. As a consequence, we find a kind of an conformity to the judgments of the courts. Now, be it contract labor, be it on ADFI, be it on PF, basic wages of PF, be it, there are a lot of constitutional bench judgments, which has evaporated all the kind of confusions that we used to have. So that is the advantage. So what I find that there are a lot of things in these codes. For instance, what Bipin was pointing out as far as compliance is concerned, if you go through the four codes, you will find the intent of the legislature is very straight and clear, that inspector will not remain an inspector. They will be more of a facilitator. Now, but having said that, what has happened? They have been also being given with power of an inspector, and there will be web-based inspection. They can put you in this, and there is a criminalization of offenses. So they may put a fine on that. It may go to the court. But I'm telling you, the compliance is going to be interpreted in the new way by the court. So until this evolves, how it evolves, that has to be seen. So that is very important. So one of the losing point of the laws going away, that the collective wisdom of the judiciary for last 50 years might to an extent be not available to us.
Okay. Understood. The point taken both from you, Vipin, as well as from you, Deepanjan. Now, obviously, any discussion in Gemba HR primarily focuses upon not so much on what exactly happening in the environment, but focusing on how it is going to impact. How does it impact my working? What are the big ticket changes which would happen in the way in which we deal with human resources in the country? What are these couple of big ticket changes? I'm asking both of you if you can, so that we know that these are the big areas that we need to be ready about. That these are the changes which can bring in, and then maybe from these we'll select a couple of them and discuss those further, which are the ones which have got the maximum impact on industry. Over to both of you. You can go ahead and first decide on what is a list of which are the most critical things which are going to impact us, and then let us look at one or two of them and see it in detail.
Yeah, Deepanjan, I think you're on mute. Yeah, you were saying something, Deepanjan, I think.
So three things that is going to mostly. Now, there has been a lot of hue and cry in the industry with wage, the statutory things is going to increase and blah, blah, and all those things. That is not the case, I tell you. As far as Provident Fund is concerned, there is not going to have any kind of an impact as far as as per my opinion is concerned. Why I say so? Because you see, if I take the present Provident Fund into consideration, and even if taking the in context of the Vidya Mandir case that came in, all your wages, including your allowances, which are regular in nature, will be treated as a part of basic wages, but that is limited up to 15,000. If your wages is, suppose your basic is 18,000, will I need to take all your components? The answer is no. So similarly, in the wage code also, they are going to put in that kind of a mechanism in the social security code, that kind of mechanism has been put in place. So ESI is on the gross salary. Bonus also, they have kept the same kind of a thing, either on the amount that will be notified by the government or the minimum wage, whichever is more. So basically, there is not going to change these things. But the gratuity might have some kind of an impact for an industry. That is to my understanding as far as wage code is going to have. The second thing is they have put in a new definition called fixed term employment. And they are saying that if they are working for 1 year in the IR code, they will be eligible for gratuity. So that kind of, and I'm telling you, because though there is little bit of confusion in the code itself, the future, we are going to see more of a fixed term contract in our industry. Why I say so? Because for the first time, the government has defined what is your core activity. And actually, this has been nothing but taken from the Andhra Pradesh amendment that they have put it in the Wasage Working Conditions Code. Now, core activity has been defined as a scope of contract has been defined as a thing which is very core, whatever is core to your organization, whatever you are making in the organization, whatever your manufacturing process is making in the organization. So that core activity, the contract labor is prohibited. So if that is prohibited, you have no other way but to put in the fixed term contract, maybe that replacement. But having said that, there is another subclause to that prohibition, that if your organization is doing the process in the similar fashion for a long, I will just take your liberty to read that. Yes, it says, notwithstanding anything contained in this part, employment of contract labor in core activity of establishment is prohibited. Next, it says, provided that the principal employer may engage contract labor through a contractor in a core activity, if the normal functioning of the establishment is such that the activity is ordinarily done through contractor. So if your activity is ordinarily being done through a contractor, the industry can come and say that this is where I'm working with my contract labor. So this is how my activity goes on. So that kind of a stand, industry was going to initially stay. So that is why I was referring to that. We have to wait for that kind of a judicial scrutiny, maybe for 4 years, 5 years, 7 years, 10 years from now. A judgment will come of the Supreme Court or the High Courts, and then that will be decided. But having said that, I'm of the view that let the industry should now make up its mind to take that contract labor in the court process is going to be prohibited, because India being a welfare state, the judiciary, in case of this kind of a confusion, what they call in the legal parlance harmonious, that they use is called is harmonious construction. So they will take in favor of the, they will take it in the, they will rule in the favor of the favor of stating that the contract labor is prohibited, India being a welfare state. So that is going to happen in near future. So that is where I think the industry should take it. And the last big ticket, what I feel is very important, they have put in a new concept of national floor wages. That is, the central government will, with its committee, will notify a minimum wage, which has, it can be region wise, it can be geographical wise, it can be all over the country. I do not know how it will come, but the law says it can have various ways, and they will be about.
Deepanjan, we lost you for the last, I think, about a minute.
Yeah.
So network.
So I was speaking about the floor wage. That
okay.
is what is the, I was speaking about the floor wage. So which, and it can happen geographically, region wise, it can happen national wise. How it will come, let us see. But whatever is the floor wage determined by the central government, the state government cannot have their minimum wage below the floor wage, whatever is being declared. If it is above the floor wage in case of state government, then you cannot bring it down also. So that is what the mechanism is.
It's
So
typical
I think,
which
so initially I feel some of the states might have to take the floor wage, the minimum wage hit in their budget as far as the industries are concerned.
Great. So the 3 points which, if I just summarize what you said, one is, taking off the myths that which is there about the major changes which are going to happen in the cost impact because of the changes in legislation. It's a myth which got busted. I think apart from gratuity, there is not much of impact on many of the.
And moreover, just one more. Moreover, in the Social Security Code, they have put.
Just summarizing it. So one is that point. The second one is, of course, contract labor deployment. And the third is the concept of a national floor wages.
Absolutely, yeah.
Yeah. If these are the three, Vipin, you have anything else to add, any other component which?
Yeah, 2-3 things I would also want to add here. Now, let me first start with the code on wages, right? Now, I think one of the things which really caught fancy of all the employees per se was all the newspaper ads, newspaper articles. Every single article said your take home will go down, your employers will have to restructure the salary, basic has to be 50%. And I can say not only employees or managers, even in HR, I can say at least in my interaction, at least 50-60% HR folks also said that basic has to be 50% of CTC. So there has been, I think there's a lot of articles, news articles that have come in and all, and I will just dwell on that point after a minute. But there is definitely a change in understanding, and I'm just wearing my CNB hat because I did that part for quite a long, so it doesn't get out easily, right? Now, what happens? My understanding is, if I look at changes for a moment, let's stay on the code on wages. There were 7 or 8 acts there was a definition of a wage. Now there is one definition of wage. What it means, somewhere it will go up, somewhere it will go down, logically, right? It's very logical. It's
Yeah.
somewhere in between out of those 7 definitions. So logically, something will or other thing will get impacted everywhere. Now, what is the extent of impact? So far, whatever work we have done, I think the liabilities go up by 15 to 20% easily because of the way most of the salary structures are there in India, mostly. However, the overall wage cost for a company could go up by maybe 2% or so. Again, I'm just saying my own thing based on the companies I've worked in, based on the data I have seen. It could be a point here and there. Now, so there may be financial impact. It's not that it may not be. To what extent, every industry will differ. Because some of the people were using completely structures which were completely way off, even the commonsensical kind of things. Some of the companies were very, very close to where it is. So, but so there could be that impact. There could be impact on almost practically everything. So gratuity is going to be a big impact because gratuity goes by accrual. So that's the reason that the maximum impact comes on perhaps gratuity. There may be other impacts on leave encashments and certain other things, but most of the times it may not have such a huge accrual value because many organizations have some kind of maybe encashment and lapse kind of things. So that's one part. Now coming to let's say the social security kind of thing. Now when you look at the social security, I see most of the things. If I say gratuity, I clubbed in wages, not here. But if I look at most of the things, there are procedural. To my understanding, most of the things are procedural in nature. May not be a very huge impact. Yes, there are certain things related to. They have talked about how there will be certain let's say procedures for going to tribunal, how certain kind of expenses will be done. Yes, there are certain inclusions. Let's say there is a recognition of gig workers, platform workers. For some industry, it may be an important thing because those are the people who will start getting benefited. If I move to the third code, which is more on the industrial relation, and I think that's what Deepanjan specifically mentioned. The retrenchment one is the biggest thing that perhaps is there, and which is there, which will have more ease of the business point of view, but rather than a negative impact, more on that. And also, if I go to the industrial code, my own understanding of the key 1 or 2 points for me that I see. One is that the kind of maybe notice that is required for a maybe strike or lockout, and also the second thing, the negotiating union concept, which is the union, what kind of participation it has for the negotiating. So I think from my understanding, these are 2 or 3 very key elements which will have the maximum impact on the company. And I just talked about all 4 codes, and in my view, what are the key elements. I think from the employer point of view, again, I would say it's not a question of panicking, whether there is something that will drastically change in terms of the financial and other things. I think there is enough time to really look at the practices and understand the intent of the code and start aligning some of the things which may not be there. There could be a lot of procedural things also. Now, procedural, I may say, for the company sometimes are more like irritants than really something else. So while there has been a lot of facilitation in terms of ease, but let's say one simple clause that the final settlement of the employee should be done in 2 days, right? Now that could be something which requires a process improvement in the company. And there have been cases that companies have been holding the settlement of the employee after leaving for 45 days, 90 days. In fact, companies have there in their policies and processes that after an employee exits, we will settle in 45 days, we will settle in 60 days. There are those kind of things, and it has been misused also quite a bit. So I think, so coming back to that, I still see that there is a lot of positivity that is coming to employer, and there is a lot of balancing that is done from the employees or workers right as well. Sometimes when we are in a very big company, MNCs and big companies, corporates, we don't realize and we feel, oh, what was the need for this thing? But there is this huge chunk of population working in those companies where these things are not really given. It doesn't come easily. And I think that's where it is going to benefit a large chunk of population when we leave the typical office staff and corporate staff and say, okay, this is so easy, because for us it is given at most of the places.
Right.
So that's some additions that I wanted to just add there.
Binayak, before you get into that, giving the summary or the inferences, two things more that we have not spoken about is that the definition of employer has now changed,
Right.
and the definition of employee has been inserted in most of the codes. It
Right.
means a manager, and they have put a workman as another definition. So workman and this employee has been put intermittently in various places. So for now, if your final settlement is not done, even if he's a manager, he can go to the labor commissioner office and say, hey, my final settlement is not done. Now, one thing that is more often financial, I find it more to be a governance issue, will be one kind of an issue that industry has to deal with. As rightly stated by in that 2 days settlement, you have to face. And that really becomes a question, very challenging for the industry. So this kind of governance issues are there. But employer and employee and in the definition of employer, everywhere the contract labor is now being put under the definition has been put in such a way the contract labor becomes the employer responsibility, accountability of the principal employer, including the gratuity and bonus, which is not the case as of now. So this is the other two big tickets that we need to keep in mind.
So just we lost you, I think, for some time because it was not very clear. So what I could understand is that the definition of employer and employee has got defined. And therefore, what is so, and earlier, yeah, as we know that the worker, employee, this were something which were intermittently put in different acts, somewhere it was called workman, somewhere it's called employee. So because of this, what has been the change? Sorry, I missed out your
No. So for the employer, in the case of employer, has been now it is clear. My voice is clear.
Yeah, voice is clear.
So as far as the definition of employer are concerned, so it has been defined in such way the contract employer becomes the responsibility of the principal employer for each and every case, including bonus and gratuity, which is not the case as of now. As per the Gratuity Act, the Payment of Bonus Act, contract, your principal employer is not liable as far as the act is concerned as of now. But now that becomes your responsibility. Now they have defined workman and employee intermittently. Employee has been defined as manager, supervisor, everybody. So if your final settlement is not done within 2 days, a manager or even any level can go and put a complaint before the labor commissioner office stating that my final settlement is being not done by this company, and the labor commissioner can intervene as an industrial dispute. So that kind of thing has happened in these courts. So these are the two important things that has to be taken care of by the industry because it is going to impact them. And more of the issue what Vipin was trying to say, I understood, or is that it's more than the financial, it's the more of a governance issue that is also going to impact the industry as such. They should be ready for number of new changes that is coming in, okay, as far as their governance pattern is concerned. Right. One more important thing is very important. That is now coming to my mind is that the grievance redressal committee, as far as the ID Act is concerned, it is in 9C. Generally, most of the industry doesn't care. It is there in the Statute Industrial Dispute Act, but we don't care. But now there is no escape, because if you are going to raise a dispute either on termination, on retrenchment, or any other issues concerning industrial dispute, it has first to come to the grievance redressal committee, which would comprise of equal number of your workmen and equal number of your representative from the management, and they have to decide it within 30 days. And if it is not being decided, then it can go for that. The dispute can go to the conciliation officer or to the labor officer. But you have to
does
come.
it also look at termination in case of disciplinary issues? Or that is
Yes,
flexibility?
for disciplinary issues, they have made it that your proceeding has to be over within 90 days, which was
Yeah.
not the case as of
But
now.
does it go through the redressal committee? Maybe you have a termination.
Absolutely. It has to come through the redressal committee, and then only they can take it to this. And one change that they have made in the code, in the IR code, now no more the state government is going to make any reference of industrial dispute to the tribunal as of now. Now what happens? The dispute goes, the dispute fails, the conciliation officer gives a failure report, then the state government, if it so deems fit, they send it for a reference to the tribunal or to the labor court, and the matter is adjudicated. Now the code mandates one has to be, after the dismissal committee, to go to the conciliation officer. He has to conciliate. If it fails or whatever, he has to give his things within 45 days, and you will get a copy of the failure report, and then the either party can go and approach that tribunal. It's not the state government that is going to refer the case to that tribunal.
State government does not have
change.
the responsibility of going to the tribunal. It has to be an aggrieved party which would go to the
Absolutely.
Okay. Great. So there are several I think very significant impacts. So first, I think thanks Vipin and Deepanjan on clarifying on the wages part. Yes, there is going to be an impact, but primarily on accruals, nature on gratuity, etc., which is going to go up. The myth which came that 50% basic requires to be made, and therefore, and the actual impact will be totally a function of what they are currently at. If the current is close to what is recommended, then the impact is not significant. But if you are currently very wayward in terms of your salary structures, yes, there would be a financial impact, because that is the degree of change which is going to happen. So this is mainly on the wage code. Another very important point which comes in is that the definition of employer and the definition of employee, and some clarity in terms of, certain responsibilities between principal employer and the contractor or the employer, which used to be there, is exactly these points on bonus and gratuity, and who's responsible for making those payments. Those clarities are very important. Also, the fact that yes, now even white-collared people who are not coming under the A of workmen, they still have certain rights in which, especially in case of full and final settlement and other such issues, can approach the Labor Commissioner. So these are various significant points. Let us come to one point which I think we have enough for about one particular point where I can take your detailed opinions on. What is that point which has got I think, the maximum impact?
See, to my mind, what is coming to me is that mostly nowadays the industries try to rely upon the contract labor, because from the liability point of view, from the cost point of view, from all this kind of, and that is why you will see, if you take the statistics, it's burgeoning. Every year it's going up. The contract labor is going up and the permanent employees are coming down. But that mentality has to now go, because with the code coming in after the wastage code, there will be a new kind of an employment that is called the fixed term employment is going to replace them, at least in the code process. That is going to have a major impact. Money wise or budget wise, it might not impact you, because you might be keeping those contract labor only in fixed term contract. Industries which will take the shield of stating that my working is being specifically done in this way only by through the process of contract labor, they should be ready for more of a litigation, because I'm sure the appropriate government will come and tell you to stop, because this time that the kind of the Section 10 scheme of things in Contract Labor Regulation Act is not there. So there is no advisory board. There has been rather an authority being given to a person. So he will come and adjudicate, quasi-judicial adjudicate. No, this is the court process. You have to put it, and then you have to go on a go for an litigation before the courts. So that kind of a litigations I'm looking forward to many, if not plenty. And finally, the law will evolve as to how it is that section 57 will be interpreted. So that is one thing.
It is definitely a major shift in terms of not only the legal perspective, but also in the way people would employ.
Absolutely.
Earlier, it was very easy. You just call the contractor, add some people, and they. But now it is not that. It has to come through the fixed term employment route. And once it comes to the fixed term employment route, there are certain legalities for which the employer, the principal employer, will be directly responsible, not the having that indirect responsibility when the contractor fails to implement. So one is obviously this change of how we deploy temporary manpower, either through contract or through fixed term contract. That is something which is going to change, and this is something which I think any industry that I've worked in, there was always these question on how do you handle peak manufacturing and how do you handle actually lean manufacturing. So you have periods in time where you have very high requirement of manpower because your production demands are higher. And then you had periods when it's a lean period, and that's the nature of the industry, nature of the market. Nothing much to do about it. I remember, Deepanjan, it's in your organization only, I think the winter season used to be where all the cream that gets made. And therefore, the number of manpower that you deploy at that point of time is substantially higher. I had done SKU-wise check on what is the demand in the lean period and the peak period. In certain products, it went up to say 700 to 800%. It was only manufactured during the winter season. Therefore, how do you take care of this additional manpower requirement only for that period? You cannot employ these people for the entire year because that is going to be because those people would be idle in the rest.
Vinayak, I'm maybe just adding a point here. Actually, for seasonal, it is permitted even in the new code. So
yeah, seasonal it is permitted. Right.
Seasonal it is permitted. What they are saying, trying to push for is that the contract labor is not in the core operations. So far, I think there are many portions of the core operations which have been shown as ancillary operations,
Right.
and maybe there is a contract labor there. I think seasonal may still be okay. Seasonal may still be permitted, and I think again, I will put still that part. I don't think government's intent is to kill the industry. The intent is the malpractices related to it should go off, and the workers' rights are protected. So I think to that extent, there is some reasonability in exclusions. But again, see, a lot again depends on how the entire thing moves, because over a period of time you see how the implementation and other thing starts. At least the intent wise, the seasonal and those things are permitted in the new code also.
Yeah. I think
adding to that.
No,
you are speaking something. Please come. I'll adding. That's why I was adding. Apart from the legal perspective, suppose if it is not seasonal in nature, suppose from an industry which is not seasonal in nature, in core activity, if you are putting a fixed term contract, from the higher perspective, after a year, 2 years, 3 years, you can understand how difficult even if it is to remove people, because they might also get unionized and they will be becoming a direct union member. So that is another practical aspect of things. Apart from the legality, the IR kind of issues can come into play, which an IR head or the plant head, HR head or the HR head has to confront. Then the come of the wages.
Yeah. Apart from that risk, I think the challenge would be that, see, when you have this, my thought basically is that in core operations, there is a concept of having, firstly, if there is a particular responsibility, a core operation that you're doing. Now, for example, the quality of the product. Now, if it's a permanent employee, there's repeatability. The same person comes and does the work there, which in a lot of cases, when you're deploying contract labor, you don't have that option. Sometimes X comes, sometimes Y comes, sometimes Z comes, depending upon availability. But, assigning quality responsibility, assigning and having that, attitude towards my product quality, the pride for quality, is very difficult if your workforce is a contractual workforce and the people actually change. They do not have a, set responsibility, a set workstation where they work. So that is something which is another aspect which comes in when we are talking about deployment of contract labor. But yes, fixed term contract, people whom you want to do, but and when there is a requirement to reduce your scale because of market demand, you have that option of going into it. But I think one of the challenges which is also there in deploying contract workmen is that, can you actually drive quality and drive pride in your production if your workforce don't feel that they belong to the organization? That is a big challenge. And forget about the A part, which is the IR part. Yes, they will get unionized, that risk. I think more than that, are they your people? Can you rely on them to, really be engaged and really uh, do bring about, quality in the way they do their things, deliver quality for you? That is, I think, a bigger question, which has always been, whenever we talk about contract workmen, this challenge of, yes, the ease of deploying contract workmen is one part, but whenever we used to go back to my manufacturing colleagues, the question used to be, we need repeatability. We need people who know the place. We need people to whom I can assign responsibility. Because that's very important, because finally the product quality, etc., is something, it's totally in the hand of the people who are doing your core operations. And especially the part which you said, Vipin, that a lot of times we ensured that the parts of the core operation were also shown as ancillary. But that also led to various operating challenges. I remember even stores, the raw material stores, the people who were doing the dispensing. Now, if I had the same person, if I had repeatability, if I had a permanent person, that person knew that if this is the formulation, this is what I got to provide. Every day there's a contract worker and therefore there is some change in some frequency, you always have the risk that the dispensing is wrong. Because those are actually activities, the core, they are defined as core activities because that repeatability, because that skill of the person is very important. So, especially for quality or productivity, things like this. So that's a very important thing, and it has been a challenge, of course. And therefore, if in a fixed term contract scenario, how do we also ensure, apart from ensuring that their rights are taken care of, how do also ensure that they feel that belongingness, they have that, aid to your organization, that connect to your organization, that yes, they will take care of quality, they will take care of the standards which are there, take care of safety, take care of environmental things. That is very important. That how can we train people very fast and ensure that this belongingness is there? That's a very important part which will come in when your workforce is, to a large extent, would be. It's not that we don't have the challenges. In a lot of organizations, you have a large set of contract workers. And it's always been a challenge of ensuring they know quality, they know the operating procedures, they know safety standards. So those are also things which would be coming into play, and those are things which we really need to work around.
So, Vinayak, I will just add part on when you said fixed term contracts, and I will try to split into two categories, more like white collared, maybe slightly senior and corporate, and the second is the blue collared. Uh, See, again, it is again a mixed thing for both sides. Now, one way we can say, would organizations be using it only that just giving fixed term contracts and not giving, let's say, till retirement kind of thing to many jobs in that? And I'm first time talking about the white collar. But I think so that's one part which may also happen to some extent. I don't know. But there is another part to it, that there are many times you need experts in your organization for certain times. And many a times organizations are also not very clear what to do. Should we route them through the manpower agencies? And then many of the, I would say, experts, they don't want to be part of manpower agencies to
Yeah.
and show that, but they would prefer a direct contract with a good MNC, which could be for 2 years. Maybe I'm a 2 year person with you, and also that I know that I will get the benefits like insurances and certain other things because I am an employee. All my rights are as just like an employee. All my entitlements are just like an employee. It's just that instead of retiring at 60, now I'm exiting in, let's say, 2 years, 3 years, 1 year, whatever, more time. Right. So there is a positive side to that also. It's not only the negative side. Yes, in blue collar also, again, I think, uh, again, when things move, we will see how it goes. But it also gives a provision to be able to hire some people for certain time. Let's say there are projects coming up, and there are a lot of big organizations getting into projects. We know this project is for 2 years. We know this project is for 3 years and all. Now, there are many times that the organizations are not passing on the right kind of benefits. The employees also don't get those kind of benefits. So then there may be a opportunity for employers to use it also as a tool for attraction better quality people and saying that you get entitled to everything when you are on this project for 3 years. And I'm talking about, there is a huge construction going on in the country, infrastructure projects, many other places. 3 years you are at one place, maybe another 3 years you may have to move to some other project kind of thing. So I think there can be a lot of positivity also, apart from maybe the challenges of maybe using it in a way where some organizations don't want to, let's say, have too many employees, that I don't want to keep too many employees for long term kind of thing. But somewhere I think legislation is only one part. The market forces balance out a lot of things. So even if I say whatever are the minimum wages, the point is skilled person commands the wage that the
Higher than that.
person market commands,
Absolutely.
right? Now, I may say whatever, if I'm hiring a CNC operator, I may not go for maybe minimum wages. I may not find a person even at maybe 20% premium or 50% premium than minimum wages. So market forces also balance it out. So to a great extent, I think it's a combination of market forces and maybe some of these provisions which will guide it. And some of the things we get wiser as when we start looking in the past, maybe few years down the line,
Absolutely.
we may be much wiser how some of these things have panned out. But at this stage, I don't see it as a big concern. In fact, I also see a lot of opportunity coming in, especially for people who are skilled.
Right. And another thing is now the employee's expectation from organization is also changing. Employees also don't want to stay in the same organization for a very long time. They also want to work from project to project. So you really have the profile of employees at different skill levels, I would say, is also that earlier I was looking at employment as a lifetime thing. I join in a company, I'll stay in this company, I'll retire from the company. Today's workforce also is not looking at long-term employment with one employer as something which is they're in. And therefore, this is also important that given the context that there is a requirement from industry to have skills for a limited period of time. It is also something which, from the employee point of view, the workforce also is looking at, different opportunities at different points of time with different organizations, project to project sort of a existence. And therefore, that actually suits well. So in conclusion, definitely, we are looking into some very positive changes through these legislations, which primarily would, govern the way in which we would be, we would look at engaging employees. The main theme is to ensure that there is compliance. Labor and employees are not exploited. That is the second most important point. And the third is that organizations now, there are certain gray areas in terms of whose responsibility does contract labor or temporary workmen is. Now there is complete clarity on how it is. And there is, of course, a clarity in terms of the definition of employer, definition of employee, and rights of white collar and blue collar both getting, same importance. These are the main things which probably would be the changes which would be there. Now for the audience, if you have any queries, any questions, you can raise it with any of us out here, any of the speakers. So the floor is open. If you have any questions, any clarifications, you can definitely raise them now. Okay, I think there is not.
Just a thought. I don't know. While you were talking, I just tried to pull one slide. I know our audience,
Yeah.
we have been talking throughout. If you permit me,
Go ahead.
I can share one more slide with the audience.
Yeah, please.
You have to enable my screen sharing.
1 second. Yeah.
So this is
Okay,
one
go ahead
thing
now.
that I have always learned, that if nobody asks question, you ask question back. So okay, 1 second. I'm just trying to pull out one document, and 1 second. So is it visible?
Yeah.
So audience quiz. I just pulled it out while we were talking. Anybody, if you want to write down in the chat box, A, B, C, because these are the newspaper cuttings that I have put in. Does code on wages mandate corporates to restructure compensation with basic plus DAS 50% of CTC? Anybody wants to just write down in the chat box? Any other? Only one response? I'm just hoping everybody is there.
No, I think a lot of them have thought is over.
Okay. Great. Okay. So maybe I will just add here the point, which is the second quiz. And the answer is here within the first, for the first question in some form. Can you see the screen?
Yes, visible.
Oh, okay.
All visible now.
I thought, so perhaps the answer is here. That what is the correct definition of CTC? Is it CTC-A? Is it CTC-B? Is it CTC-C? What is the correct definition of CTC in itself?
CTC-C, with my understanding.
Great. So the reason I brought it up was that when we say that wage code says 50% basics has to be 50% of CTC, the point is no act defines CTC anywhere. So CTC is a very corporatish term. So ideally, I can be correct at A, I can be correct at B, I can be correct at C, I can be correct at all also, because the way I want to calculate the cost of an employee. So because there is no definition of CTC, coming back to the first question, 50% of CTC carries no meaning. So what wage code in any case has in a way specified is that there is a definition of wages where there is a part which is included, there is a part which is excluded, and there are certain special provisions, and they say that the exclusion should not be more than 50% of the total wages, the way it is defined. So there is no mention of CTC, but I won't blame anybody. I won't say anything because the problem is everything was done by journalists in the newspapers, and it was so much of hue and cry that almost
Yeah.
every time you hear it and then you realize that it is a kind of misnomer spread in some form. Whereas there was no mandate, and even today there is no mandate. I can keep whatever it feels like, but the calculation of all the benefits will be done on the definition of wages, which will be as per that. So actually it doesn't matter. I can have whatever basic, because calculation will happen on the definition of wages. So Act doesn't differentiate now in terms of the allowances. There is a new definition of wages and things happen on that. So I just thought maybe I will just spend 2 minutes at the last minute for the audience because nobody asked the question, and so just brought it up just to add a little bit of zing.
I would just like to thank you because you have really brought out a very wonderful piece to make understand what actually is that CTC is all about. There's nothing been defined in the CTC as such. It's a wage code that we have to go for the definition of wages, and very excellent. I loved it. Thank you.
Great. Thank you.
I think there's a question which is coming from Chandan, which is on contract labor eligibility for gratuity. So Chandan, can you just clearly ask the question?
Good evening, sir. Sir, my question is, those who have completed 5 years in under the contractor, they are eligible for the gratuity or not, sir?
Absolutely, gratuity is a provision if somebody is working for 5 years, or if somebody is dying. Suppose there are 2-3 things that for which a person becomes eligible for gratuity. So if he's working for 5 years, obviously he's eligible for gratuity. So though there is nothing in the law that says that contract labor will not be eligible for gratuity as of now. As of now, what is happening? The principal employer, legally speaking, are not responsible for gratuity. But when the courts comes into operations, in my opinion, principal employer has to owe this requirement.
Sir, and other things, contract labor says that if contractor not paying anything, supplier is on behalf of contract labor. So at that time, the ultimately principal employer is they're responsible for that.
See, now how you define gratuity is if gratuity, if you define if it's a part of the wages, to me, no, answer is no. As of now, in the contract labor, if I'm not wrong, I think 21(4), section 21(4), principal employer is only liable for wages, maybe to an extent provident fund because of the definition of the employee. But contract labor, as far as the law is concerned, still now, as per the Payment of Gratuity Act, principal employer is not responsible. But having said that, once the code comes into operation, principal employer is also going to become responsible for gratuity of your contract labor. Vipin, if you have any other opinion, you can.
No, absolutely. And I think the way I also look at it, while we may say contract labor from the point of view of the company, but again, the employer is there. So there is an employee for that employer. So all the provisions of employers' responsibilities come there also. So they are therefore they will be eligible for gratuity if all other tenure conditions are met. So there won't be any change in that. Because employer-employee relationship exists between that contractor and the
Absolutely.
contractor.
And your contractor can be taken to the before the controlling authority.
Yeah.
It is not sure.
No, I remember in a lot of organizations, at least in the multinationals or the ones which are compliant, there is when you're deciding the daily or the monthly wage of your contract workman, you take that component and you include it. So that at that point of time, the contractor can't come back and say that I can't pay compliance. I can't pay gratuity to the person. Because to ensure that the contractor is compliant, you also have a role, even in the earlier regime. You already had that role as a principal employer. So in fact, in our costing, I remember leave, gratuity, things were costed in the wages itself. to ensure that the contractor is covered in terms of cost for doing that compliance.
In fact, Binayak, even currently, some of the best practices of governance is some companies release the monthly payment to the contractor only once they submit those PF challans and all. And they have made it a mandate that submit all those compliance reports every month and then you take your check, kind of thing. So that governance kind of mechanism.
Absolutely. I
companies
think
are-
all organizations, most organizations who are serious on compliance does that bills of contractor release after everything is furnished. Great. Folks, any other question? Trainees organize session for a period of 6 months to 1 year. This from Kosturi. Either of you can take this.
Maybe Deepanjan, you are the legal expert.
No, see, no, see, as far as the trainees are concerned, you have to first of all find out whether the trainees are governed by the Apprentice Act. If they are governed by the Apprentice Act will apply, and in that case, you don't have that kind of a statutory liability. Otherwise, to me, trainee should be covered under all the statutory norms, and they should be covered under all these statutory norms. And even apart from the legal aspect, you take certain kind of a governance aspect also. Suppose if you're not covering a trainee under, suppose his salary wages is less than 21,000, if you're not covering within the ESI and other things, you might get into problem. So these are the things that also you need to take care from the governance part of is concerned. But if a trainee is under the Apprentice Act, it will be only governed by Apprentice Act to be short. And if they're not, then your trainee must be covered under the Provident Fund, ESI, or whatever statutory norms that is applicable.
The apprentice you can also now take under the NATS and the NAT schemes, right?
Yeah, they have to be registered under NATS. Only they can be told as an apprentice.
Yeah.
So Kosturi, your answer is, you got your answer? What about consultants or subject matter experts onboarded for specific project and receives a lump sum amount as fees? This from Suchandra.
So for the yeah,
Please carry on. Please carry on.
No, please. Okay, should I? As far as the consultants are concerned, there has been an upward number of court judgments. They are also covered under the statutory norms, provided that they fall under the purview of it. Suppose if you are keeping a consultant who is working regular in nature and for a fixed term period or whatever, and his wages is less than 21,000, then ESI will attract to him. You cannot escape the ESI. If you are keeping a consultant with wages, or you are keeping him only 10,000 or 12,000 per month, then Provident Fund will be attract to him. So there has been judgments to that effect. So consultant, employment, everything has to be covered under statutory norms. They cannot escape just because they are consultants.
Yeah. The only thing I would maybe add one point here is, if there is a consultant and it's a more like a work contract for a consultant. For example, I am a CA and I'm doing work at 5 companies. Then you have not really hired me as a laborer. In that case, it doesn't come in because you are paying for a service. It's a service kind of contract, and maybe that CA is working for 6 organizations. Then those things don't become applicable. But if it's a kind of exactly what Deepanjan said, if it's a kind of an employment that the person is fully engaged with you, working like all other employees full time with you, and then it is only a way in which you have engaged that employment term, then the kind of maybe these kind of benefits and things should come across.
Absolutely.
Yeah.
Suchandra, does that answer your question? Yeah. Great. Good. Just waiting for any other questions if any one of you have, or we can wrap it up. I think that would be all. Thanks a lot, Vipin and Deepanjan, for sharing these insights. This apparently, yes, there's a lot of eye-opening things in what is going to happen in the times to come, because, and I think the government's effort, to make India a global hub for manufacturing through the Make in India initiative. This act is the changes and bringing in these labor codes is perhaps a step in the right direction. Obviously, there will be changes, there would be new situations which will come up, and through different legal interpretation of situations, legal interpretation of the codes, we would be able to, come to, ensure that the gray areas become clear to everyone. But to a large extent, this has been a lot of the questions, a lot of the, issues that we faced as HR practitioners or as, business professionals in terms of the labor legislation, because there was so much of confusion, too many acts, as Vipin and Deepanjan, both of you highlighted that the same thing can be very differently interpreted in different acts. I think those are the ones which fundamentally get cleared. If there is a definition of wages, it's a definition of wages. Who is a worker? Who is an employee? These were some challenges which we faced in our while we dealt with the earlier legal framework that we have for labor in India. Thanks a lot, all of you, for being present. We would be having these sessions on Tuesdays and Thursdays. The session for Thursday is already announced, which is on candidate experience. And same time, 7:30 p.m. Indian Standard Time, we would be there. Thanks a lot, Deepanjan. Thanks a lot, Vipin.
My pleasure. Thank
We
you.
have done the recording of this session. I would be sharing the recording and the link to the YouTube link, which people can access and see for a later date. Thanks a lot.
Thanks
Thank
a
you
lot.
so much. Thank you. Thank you.
Audience also, and thanks, Vinayak. Thanks, Deepanjan.
Thank you.
Okay.